Well, good afternoon and welcome everyone. My name is Leah Hilton-Camp and I'm the President of the National Environmental Law Association in Western Australia, and I'll be chairing this session today. Before we continue, I would like to acknowledge the traditional owners of the lands on which I am today, which is the Whadjuk people of the Noongar Nation, and I pay my respects to their elders past and present and their continuing connection to the land. Our speaker today is from Norway and she has a fierce passion for environmental law. Klimentina Radkova is a recent LL.M graduate in public international law from the University of Oslo. She is a lawyer at Greenpeace Norway and is passionate about legal issues concerning climate change, biodiversity, and the interaction between environmental law and human rights. She wrote her thesis on the impact that the Paris Agreement is having on domestic climate change litigation, and that will be the topic of today's webinar. I encourage everyone to use the chat function to ask questions throughout today's webinar, which I will then put to Klimentina at the end of today's session. Welcome, Klimentina, over to you.
Thank you so much, Leah. Thank you all for joining today. I think I'll just jump right into it as I have quite a bit to share with you today. Let's see. Are you seeing my main screen right now?
Yeah,
with just the presentation?
I can see your presentation.
Perfect. So yeah, I will be taking you through some of the findings of my thesis on the role of the Paris Agreement in domestic climate change litigation. Just a quick bio on me. I attained my LL.B, my Bachelor of Laws, at the Hague University of Applied Sciences between 2016 and 2020 in International European Law. And there I specialized in public international law. So my LL.B thesis had the title, "Has the adoption of the Aarhus Convention advanced the legal standing of NGOs when exercising the right of access to justice granted to them by Article 9.3. Then my LL.M. I attained at the University of Oslo between 2020 and 2021. And my LL.M. thesis is on the role of the Paris Agreement in domestic climate change litigation, which of course I will be sharing with you today. Currently, I actually about a month ago started a new position as a climate energy advisor at Greenpeace, as well as a campaigner there. So just to make sure, you can only see my main presentation, right? Not my speaking notes. Okay, great. Thank you. So why did I choose this topic in particular? So both my academic career and my professional path have been largely determined by the urgency of the climate crisis. And I decided to turn my focus to international environmental law when I was to choose a specialization during my bachelor's degree in The Hague. And the main aim of this thesis in particular is to present and analyze the different interpretive approaches applied by judges to the Paris Agreement in recent domestic climate change litigation, which then have been used to further define the scope and meaning of domestic law in light of the agreement. And consequently, this reveals a multi-level interpretive process of both domestic and international law and the inevitable interlinkages between those two. And I guess on the basis of those findings, one can make some suggestions on the role of Paris and its context within domestic climate change litigation. And it can also be used to make determinations on the very heavily disputed legal meaning and nature of the agreement, as well as justiciability. If the climate litigation trajectory of today continues in the same direction, because we have seen such an increase of climate change litigation in the past years, it is likely to become one of the most effective enforcement tools in the sphere of climate change and environmental law in general. And thus, I thought it might be important to assess the role of international law in this context, and more specifically relating to the Paris Agreement. And this can also be used to inform grounds for argumentation on the basis of the Paris Agreement for future claimants, as well as help judges who find themselves before similar legal considerations make informed decisions on theories, practices, and consequently decisions relating to these issues. So yes, my basically question was, what interpretive role does the Paris Agreement play in recent domestic climate change litigation? And here are the three cases I decided to focus on. So firstly, the Urgenda Foundation versus the State of the Netherlands, which was at its last instance decided by the Dutch Supreme Court in December 2019. So actually while I was in The Hague myself. And I generally refer to this case as just Urgenda or the Urgenda case. Next, we have Neubauer et al. V. Germany, which was decided at the German Constitutional Court, and it was decided in March of 2021. I refer to it generally as the German Constitutional Court case. It's one of the few climate cases that have gone through the Constitutional Court there. Lastly, I chose the Milieu Defensie or Friends of the Earth, Netherlands versus Royal Dutch Shell. And that was decided in June of last year. And as you can see, all of these cases are quite recent and originate from more or less the same legal time period, I would say. And this is, of course, not a coincidence. It was sort of the main deciding factor when selecting the case law for the analysis. And I was making this decision on what to write in my thesis on in summer of last year. So this was very much in the air at the time. And besides these cases being extremely relevant and fresh at the time, there was also an interest in comparing case law, which was decided, around the same time, similar region as well, to sort of determine the extent to which climate change litigation is moving in similar direction in different domestic courts. So I also chose these particular cases because I had some knowledge that they did address the Paris Agreement to a quite heavy extent. Of course, the Urgenda case is well known to all of us, assume, due to its groundbreaking findings. Consequently, the Shell case from the same legal system was selected for this analysis, as it sort of uses a lot of the same legal basis as the Urgenda case, but it pertains to a private actor. So I not only wanted to see how the same legal system would address corporate responsibility in the context of Paris Agreement, but also highlight the development between the two cases in the Dutch court system. What has time done to those considerations? And then the German case was chosen due to the extreme significance of making a consideration on the Paris Agreement in the German Constitutional Court and pertaining to the German Constitution. And I also thought that using choosing this case would make for an interesting juxtaposition with the other two cases, and showcase that although they come from largely a similar region in Europe, they do not necessarily influence each other's interpretative approaches on this matter. So I'm going to run through the Paris Agreement quickly, as I suppose that most of you are quite familiar with it, but still just to set up some context. It is legally binding as defined by the Vienna Convention. It is adopted under the UNFCCC. It has a very broad geographical scope, as it's currently signed by 195 parties and ratified by 193. So it means that it covers about 97% of global emissions, which is very good coverage. It contains both legally binding and non-binding obligations, but the agreement itself is binding. The objective and purpose of the agreement is found in Article 2, and it reads to enhance the implementation of the convention, meaning the UNFCCC, with the aim to strengthen the global response to the threat of climate change. And we are all familiar with the main goal of the Paris Agreement, holding temperature increase to well below 2 degrees above pre-industrial levels, and pursuing efforts to limit the temperature increase to 1.5 above industrial levels. So the legal nature of the Paris Agreement and its obligations have been heavily debated over the years. However, I think it can best be described as mixed or cross-cutting in its normative architecture. For instance, the goal to hold the temperature rise to well below 2 degrees and an effort to limit to 1.5 degrees includes an obligation of conduct and not one of result. This is because parties are obliged to employ their highest possible ambition within their national determined contributions, which is the main tool found within or used in the Paris Agreement. So the commitments within the national determined contributions are not binding, but represent an intention to achieve them. The agreement reads in Article 4.2 that parties shall pursue domestic mitigation measures with the aim of achieving the objectives. Thus, it creates a due diligence requirement, meaning the parties have an obligation of conduct to aim to achieve, but not necessarily of result to the temperature goal itself to achieve the temperature goal. So the aim to achieve is binding, but not necessarily the result. And most legally binding obligations found in the Paris Agreement are procedural in nature. And most of them include preparing, communicating, and maintaining success of nationally determined contributions, or providing information necessary for clarity and transparency and understanding. So those are things that guide conduct. To communicate an NDC every 5 years. These provisions guide conduct and they are binding. However, the result is not. And while the agreement and its further interpretation in the Paris Rulebook, which I'm sure Dr. Voigt talked a lot about, does provide guidance as to the conduct and level of ambition expected by parties, they do not provide a template for the substantive content of the NDCs. So this aspect, what should be included in the nationally determined contributions, is largely left in the hands of the signatory parties, which is perhaps what creates a bit of a conflict between ambition and action. So going to the first case, the Agenda case, the claimants were environmental non-governmental organization, or Agenda, and 886 citizens. Agenda argued that the greenhouse gas levels that the Netherlands was emitting at the time would lead to severe and potentially catastrophic consequences, and argued incompatibility with a duty of care standard established in Dutch tort law, actually, as well as Articles 2 and 8 of the European Convention on Human Rights, which protect the right to life under Article 2 and the right to private and family life under Article 8. The organization was seeking a declaratory judgment and injunction to compel the Dutch government to reduce its greenhouse gas emissions. And although representing the interests of citizens who have not yet been born was quite unconventional, this was accepted by the court. And by referring to the organization's aims to strive for sustainable society, as well as the Brundtland Report, which introduced the term in sustainable development and argues that it includes an element of intergenerational equity. So this was quite revolutionary at the time, that the organization was sort of allowed to represent interests of future generations as well. Thus, the court accepted that argument and stated that future generations have a legal standing and interest in present-day disputes as well. So yes, the Urgenda case went through all 3 court instances in the Netherlands. It started at the Hague District Court. And on the 24th of June 2015, the court ruled that the state has a duty of care to protect its citizens according to the Dutch Civil Code, or that tort law, and must level up its ambitions and take more action in order to reduce greenhouse gas emissions in the Netherlands. And to achieve this, the state must employ policies that will achieve a reduction of at least 25% by 2020 compared to 1990 levels. It was further established that the climate policy employed by the Netherlands at the time would not be sufficient to reduce more than 17% at most by 2020, which was far below the 25 to 40%, which was required by developed countries in accordance with different international climate policies. And it also stated that the Netherlands cannot use other states' obligations and commitments or lack thereof as an argument to not cut back on its own emissions. And the court gave the opinion that measures requested by Urgenda are not unacceptably costly, and that reduction helps toward mitigating dangerous climate change in general, and that Netherlands should lead by example in upholding its own commitments and cannot use the fact that others don't cut on their emissions to not cut on emissions within the Netherlands. The appellate court upheld this decision, but had a bit more focus on human rights. And then this was again appealed by the Dutch state, and on December 20th, 2019, the Dutch Supreme Court upheld the previous decisions by confirming that the Dutch government needs to reduce its emissions by 25% compared to 1990 levels by the end of 2020. So it gave them quite a short time frame there. But yes, as the first instance was decided in 2015, this sort of window became smaller as it moved through the instances. It further established that by not committing to sufficient emission reductions, the state infringes upon the rights to life and private and family life of its citizens, according to the European Convention on Human Rights. Some of the court's arguments used for this finding. So they made some findings on the dangerous climate change and science. And the court begins its reasoning by stating that a consensus within the climate science community as to the need to limit global warming to 2 degrees to avoid the effects of dangerous climate change has existed since 2007, which was when the 4th IPCC assessment report came out. Here, the Paris Agreement is referenced for the first time as a legal basis to support that claim. And they stated that the temperature goal serves as an anchor. The temperature goal found within the Paris Agreement, we can see serves as an anchor signpost throughout all 3 judgments, as many of the judges' arguments are made on those temperature goals. Another very interesting reference to the Paris Agreement is made when the decision provides for an absolute reading of the Paris Agreement by stating the convention stipulates that global warming must be kept to well below 2 degrees, which it does not stipulate. That is not something that the convention says. The convention, as we already discussed, calls for an aim to keep global temperature to well below 2 degrees. So this statement is quite surprising. And yeah, as I stated, the Paris Agreement generally strays away from utilizing such definitive language textually. So we see here the court employing a teleological approach, looking at the context by interpreting the agreement according to its object and purpose, which is to limit the rise in temperature to below 2 degrees. But it does not say must. So it's hard to imagine that the representation was an oversight or error mistake on the part of the Supreme Court judges. I think Rather, such an interpretation, although striking, seems very intentional on their part and is perhaps employed in order to strengthen its reasoning of the cuts it demands later on in the decision. It can also be argued that the judges wanted to make a statement as to the way the Paris Agreement should be interpreted in 2020. Nonetheless, shows a very significant and revolutionary interpretive approach, and also, as already stated, highlights the sort of common responsibility that everyone has to cut their emissions. So the Court of Appeal, turning to international law, as I stated, the Court of Appeal had a bit more focus on human rights law and international human rights law. It stated that the Netherlands' human rights obligations, and more specifically Article 2 and 8 of the ECHR, have been violated, and the appeals court used the Paris Agreement to help define the scope of the state's duty of care by arguing that dangerous climate change can lead to the loss of life and a disruption of private and family life, and that this was further confirmed by the Supreme Court by stating that by not employing ambitious enough emission reductions, the state is violating its citizens' rights to life and to private and family life under the European Convention. And the court established that human rights obligations under the ECHR, and more specifically Article 2 and 8, create a duty to protect from immediate threat, and then categorized hazardous climate change as immediate threat. Thus, the state has a duty to protect from such immediate threat. And then the failure to apply such reduction violates human rights obligations. And while this is, again, quite a bold interpretation, it has been quite criticized in the context of the Paris Agreement. It also showcases the same teleological contextual approach of the court on part of the judges, as the treaty's preamble itself places importance on respect for human rights obligations in tackling climate change. And the judgment also established a precedent in stating that the duty to protect also includes threat that will only materialize in the long term, thus applying another principle in environmental law, and namely the precautionary principle in the context of safeguarding human rights. All in all, there's little doubt that the agenda decision is, through all instances, a revolutionary one. Looking at it in the context of the Paris Agreement, it is the first judgment to truly give teeth to the treaty by employing teleological interpretive theory. The result of this is a judgment which, while not entirely perfect, is full of strong and, for many, surprising elements. Statements on the state of the environment, the legal character of the only comprehensive agreement on international climate change, and the necessity of urgent actions are made, and that is very, very significant, very important. Moving on to the next case, the German Constitutional Court case. The case largely revolves around the German Climate Protection Act, or the CPA, which is the instrument implementing the Paris Agreement into domestic law, thus making the agreement's goals binding under German law. As German law follows a dualist legal tradition when it comes to international treaties, the Paris Agreement had to be transposed into domestic law. The act affords protection against the effects of global climate change by limiting the increase of global temperature to well below 2 degrees and probably 1.5. And another purpose of the act is to help Germany reach its obligations of greenhouse gas neutrality by 2050. Another relevant legal basis here is the Basic Law, or the German Constitution, through which Article 20A gives protection to the natural foundations of life in animals. And the main issue here is paragraph 3.1 of the CPA that states that emissions should be gradually reduced by 2030 by at least 55% compared to 1990 levels. However, the obligations in this respect made within the CPA end there, and makes no concrete suggestion on the necessary measures to be employed by Germany after 2030, especially for the state to reach 2050 carbon neutrality goal. And this suggests that then the measures have to be accelerated after 2030. They would need to be a lot more drastic, speedy, urgent, and this sort of places an unfair burden on future generations as well as current generations living in the future. That it was the main complaint by the claimants, and the claimants were a group of youth climate activists from Germany, Nepal, and Bangladesh, and their main complaint, as well as what I just mentioned on the unfair burden, is that German Federal Republic has failed to introduce a legal framework sufficient to reduce greenhouse gas levels in order to meet a 1.5-degree goal. And they make a differentiation between a 1.5-degree goal and a 1.55 to well below 2-degree limit. So the claimants state that failing to meet the 1.5 ambition would endanger the lives of millions and risk the crossing of tipping points with unforeseeable consequences. So due to this failure of the state, the claimants argued that it has failed its constitutional duties to protect their life, health, and property and violated their fundamental right to future in accordance with human dignity. And again, they put on focus on the intergenerational aspect by claiming that there would be an unfair burden onto the next generations due to the missing policy for reductions past 2030. So the decision was made on March 24, 2021, and the Constitutional Court found that there's a fundamental right to climate protection. However, in terms of the complainants on the 1.5 particularly claim, the court found that it cannot be established that the legislator overstepped its discretionary bounds by taking the Paris Agreement as a basis for the Climate Protection Act and applying a well below 2-degree threshold rather than a 1.5-degree one. So the claimants were of the opinion that the goal should be 1.5 degrees, and the law called for exactly as Paris is worded, so well below 2 degrees and aim for 1.5. And they found, the claimants were of the opinion that that is not sufficient. It should be a specific 1.5-degree cap. However, the court found that such a consideration cannot be made based on normative assumptions. And while it did state that perhaps a 1.5-degree scenario is much more favorable one, it cannot be ruled out that that human rights will nevertheless be sufficiently protected by the specific Paris target of increase to well below 2 degrees. Limiting increase to well below 2 degrees and preferably 1.5 degrees. The court did, however, find that by not committing to ambitious enough reductions in the present, not having a concrete reduction plan post-2030, the German state offloads major emission burdens and thus violates every type of freedom protected by fundamental rights of the future generations and current generations living in 2030. And it states that fundamental rights are intemporal guarantees of freedom which provide protection against the comprehensive threats to freedom caused by the disproportionate burden as required by Article 28. So they did find that there is a disproportionate burden put onto future generations due to this lack of policy post-2030. And it established, it called for a revision of that law by the end of 2022. So we will see what that will look like. So the main arguments here used, the court held that Article 2.2 of the Constitution encompasses protection against impairments caused by environmental pollution, regardless of who or what circumstances are the source of the impairment. And as the state was afforded a considerable amount of discretion in fulfilling those protection duties, and as it found that discretion was not overstepped, it cannot ascertain that the duties were violated. The legislator did not overstep its decision-making scope as it has based the CPA directly on the Paris Agreement and has designed policies in accordance with the specific wording with the temperature limits found within the agreement itself. And those do state well below 2 and preferably 1.5 rather than just 1.5. In this particular finding, we see a very textual, literal interpretation of the Paris Agreement. It contrasts to the agenda decision, where the judges read more so between the lines, focusing more on the purpose of the treaty rather than the literal text. And the German judges put a lot of emphasis on what exactly the agreement says. They make the distinction again between the sort of two goals or the wording and what it means. And the court even acknowledges, as I said, that a 1.5 degree target is advisable, but nonetheless does not find a violation in this particular case. As I already stated, there was a violation of citizens' fundamental future freedoms, and the court also established an objective duty of protection arising from Article 20A of the Constitution. And the court states that precautionary steps should have been taken in order to ensure that climate neutrality transition respects fundamental freedoms, such as fundamental rights to a future consistent with human dignity. This is quite groundbreaking because the agenda decision did not make a legal consideration as to the fundamental rights of future generations, although it did allow the claimants to argue for their rights. But here we see one of the first time where the decision actually makes a consideration on future generations in this way. And the approach to science here, the Paris Agreement plays a very significant part in this case, as the CPA serves as the instrument implementing the agreement into German law. Thus, the question posed by the claimants relates largely to the compatibility of the Paris Agreement with the CPA, with the Constitution and fundamental freedoms within it. So for this reason, the agreement and consequently its temperature goals, again, here serve as the overall foundation for the entire decision. And while acknowledging the fact that limiting the global surface temperature would mitigate a lot of the consequences of dangerous climate change, the court's considerations focused on the extent to which the domestic climate law is in line within the Paris Agreement. So not much really outside of that, but how much is the domestic law in line with the Paris goals? And as I said, the court took the agreement's goal in a very literal sense and ruled that as the CPA employs the same goal as the Paris Agreement, the legislators have not overstepped their power. However, a very interesting aspect of this decision is the use of the Paris Agreement in interpreting the German Constitution and thus freedom stemming from it. It states that Article 2A of the Constitution does not contain a justiciable standard as to what emission reduction must be put in place, in order to safeguard the freedoms stemming from it, and that this task is largely left up to the legislator. However, it does stipulate the fact that although the provision does not provide specific reduction targets, it does not preclude it from possessing a binding nature. So the court confirms that the provision has been specified by the CPA, which is based on the Paris Agreement, therefore giving a constitutional character to the Paris Agreement. And this showcases a very close and important reading of the climate agreement by the Constitutional Court. Again, the German Constitutional Court here underlines the fact that climate change cannot be tackled by one state on its own, and thus the constitutional provisions of climate protection is inherently dependent on international cooperation. And also references these principles, which I have listed here, also largely found within the Paris Agreement. So to sum up, as stated, the Paris Agreement plays a big role in this case, as the dispute is based on the law which transposes it to domestic law, namely the CPA. In this decision, a more literal textual approach is applied to the Paris Agreement, and it's well below 2-degree temperature goal, thus finding that as long as the German legislator is in line with the exact wording of the provision, it did not overstep its discretionary boundaries. The court does, however, find a violation of citizens' future freedoms and an objective duty to protect future generations. Another groundbreaking aspect of the decision is the fact that using the CPA to define a constitutional provision, the court thus gave also constitutional character to the Paris Agreement. Yes, through the decision, judges consistently reference the overarching principles of the Paris Agreement as well. Moving on to the last case, the Shell case. So the claimants are Friends of the Earth, NL, or Netherlands, and 6 other environmental NGOs, as well as 17,000 citizens. And the claim was that Royal Dutch Shell's climate change contributing activities violate the duty of care required under Article 6.162, which is the same as the one used in Urgenda, the tort law basis, as well as violate human rights obligations under Article 2 and 8, as already discussed in the previous cases. And the plaintiff's main wish was for a ruling that would demand the reduction of CO2 emissions by 45% by 2030 compared to 2010 levels, and climate neutrality by 2050. In accordance with the Paris Agreement, they referenced the Urgenda decision, which found that inadequate climate action on the part of the state violates the duty of care standard to its citizens. The plaintiffs in the Shell case follow a similar line of argument by trying to extend this duty of care to private companies as well. And this Dutch Civil Code article outlines a violation of a right, an act or omission in conflict with legal obligation or with what is generally accepted according to unwritten law to be deemed as unlawful acts. So they argued that because polluting and fossil fuel production is not unlawful in itself at this time, and although Shell technically is in line with current laws, the plaintiffs lean on this provision, arguing that reducing pollution levels is part of what is generally accepted as unwritten law, and thus creates a duty of care on part of the corporation. And the reasoning for this is the fact that according to the best available science, a global warming of 2 degrees will bring all-encompassing danger to mankind, and the inaction of parties with substantial influence to prevent this danger, such as Shell, thus constitutes unlawful endangerment. And the argument also outlines accusation of Shell's knowledge of climate change and further its inaction and release of misleading information to the public. Thus leading to Shell unlawfully endangering Dutch citizens as a result of actions consisting of hazardous climate change. The decision was made in June of 2021, and the district court did agree with the plaintiff's claim that Shell is acting in violation of unwritten standard of care in accordance with the Dutch Civil Code. And the court applied this standard of care to the company's policies, emissions, consequences of emissions, and the human rights international regional obligations. So the district court ordered Shell to reduce its scope 1, 2, and 3 emissions by 45% by 2030 compared to 2019 levels across all activities. And here are some of the court's arguments. So the court uses citizens' rights to life and family life, and obligation included in them in order to answer the question stemming from the Dutch Civil Code article, namely what according to unwritten law has to be regarded as a proper social conduct. And this is an interesting perspective as the court applies the European Convention on Human Rights, which is an international treaty normally working in a vertical manner, in a horizontal manner, to private entity, which traditionally does not have human rights obligations towards individuals. And the court refers to Urgenda in its interpretation of the scope of Article 2 and 8, which we already spoke about, and including a protection against dangerous climate change. And as the horizontal application of a human rights treaty is rather unusual, the court backs up this argument by referring to Shell's support to the UN guiding principles, which represent a global standard of expected conduct for all businesses regarding human rights. However, those guiding principles only have a soft law nature and do not pose any obligations on part of the companies. Nonetheless, the court used the European Convention in conjunction with the guiding principles in order to define the content of the unwritten standard of care and the obligations to be assumed by Shell on this basis. Again, here, scientific background is largely determined by the Paris Agreement. The obligation pertaining to the Shell Group in cutting emissions from its own activities is one of result here. So that's what the court found, and thus the company must take the prescribed cuts of 45% by 2030. And otherwise, it can be held liable for non-performance. So that's quite interesting. Now moving on to private actors' obligation on the Paris Agreement, which also is very interesting findings. The Shell ruling is significant and historic, as already stated, as it represents the first time a court imposed mitigation obligations upon a private actor and recognized that private actors should also act in accordance with the goals, objectives, and aims of the Paris Agreement. The court referred to the COP decision on adoption of the Paris Agreement to underline the need for non-state contribution. And also points to the fact that the Paris Agreement itself implicitly calls for phasing out fossil fuels. And in further defining the role of the Paris Agreement, in this case, and possibly in climate litigation against companies in general, the court references the IPCC and states that the goals of the Paris Agreement represent the best available scientific findings in climate science, which is supported by widespread international consensus. Continuing, the court states that non-binding goals of the Paris Agreement represent a universal standard that protects the common interest of preventing dangerous climate change, thus explicitly anchoring the Paris Agreement and its goals as a scientific basis for the case at hand, even when it pertains to a private actor. And the court states that it follows this line of reasoning in determining the scope of this disputed unwritten standard of care owed to citizens by companies, which is a central case here. However, the court did not go beyond to sort of establish what this important role of private actors means, which I think is a missed opportunity here. And in similar fashion to the agenda decision, the judges in the Shell judgment applied teleological interpretation, which focuses on the purpose of the agreement rather than the literal sense of the agreement, because in the agreement, there are no legal obligation towards companies. This being the already clearly established goal of the below 2 and preferably 1.5 degree goal. The Paris Agreement references the significant role private stakeholders can play in achieving this target, and the fact that phasing out fossil energy is a big factor in achieving these goals. Here we see the court infer normative expectations as to the role of Shell, although the agreement does not impose binding obligation on private actors, as I already said. Here, the judges rather indicate what ought to be actions taken by private actors in light of the Paris Agreement, similarly to how they tackled agenda. So quickly, upon examining the duty of care Shell possesses towards citizens in protecting them against hazardous climate change, the court finds that private actors have a normative duty to act within the goals, aims, and objectives of the Paris Agreement, and that they also have human rights obligations towards individual citizens. So quickly, I will run through what we have found. Both agenda and RDC cases originated from the same Dutch courts, albeit different judges, and they take revolutionary approaches to the interpretation of the Paris Agreement. The judgment showcased a major discretionary leap by reading legal obligations and concrete standards between the lines of the instrument, a leap which for some is not entirely legally founded and has been criticized. So why could that be? One reason could be that the Dutch legal system is a monist one, meaning national and international laws have the same legal weight. On the other hand, when it comes to international treaties, Germany has a dualist legal system where international law has to be transposed into national law. As a result of this, we can see Germany adopting a much more textual approach to the Paris Agreement. It strays away from reading between the lines too much, arriving to assumed conclusions or failing to justify its findings. Nonetheless, in the case at hand, the German Constitutional Court still managed to arrive to the landmark finding and also give constitutional character to the very meticulously read provisions of the Paris Agreement. And on the flip side, we find the monist Netherlands, which applies international treaties directly. In both agenda and Shell, we see the Dutch courts stretching and bending the rules of conventional textual interpretation and apply a teleological approach, which puts emphasis on the overall purpose of the agreement rather than the exact wording. And this has resulted in two groundbreaking cases, as we looked at. Firstly, agenda, where the state is found to be in violation of its human rights obligations as a result of not applying non-binding emissions reduction in order to stay in line with the Paris temperature goals. And in Shell, the Hague District Court found that private company also has a duty to act in line with the Paris Agreement, and a failing to do so constitutes a duty of care breach. So what can we say about the role of the Paris Agreement based on this analysis? Personally, I think that the approach taken by the Netherlands is perhaps more appropriate when it comes to urgency of the climate crisis. There is a need for fresh, controversial, outside of the box perspective when we're talking about such an all-encompassing and urgent issue. And the field of environmental law and climate change is also in constant development, and domestic courts need to be able to adapt and start employing dynamic approaches, which correspond with the equally dynamic nature of this legal field and of the crisis we're facing. However, this should not come at the cost of sound legal argument and clear justiciable basis. And while the interpretive approaches found within the Dutch cases are without a doubt creative and thought-provoking, it is not difficult to poke holes within the judge's reasoning, as already displayed. And consequently, this leaves the door open for counter-arguments from the opposing side. Thus, in our eagerness to drive environmental action through litigation forward, we must not forget that this must still be done through strong and robust legal argumentation and basis. So it's a sort of balance we have to strike. And the role that Paris Agreement can play in domestic legislation, I think, is mixed. While the Paris Agreement does not have many directly justiciable provisions, we can see the willingness of courts to interpret the agreement and specifically its climate goals in a domestic context, and thus creating a justiciability in conjunction with domestic law. And the role can also be strictly complementary, referencing the Paris Agreement mostly as a source of scientific certainty. However, in the cases examined, the role of the Paris Agreement is more significant than simply a complementary one, and increases the legitimacy and implementation of the agreement as a whole. So I think it'll be very interesting, all in all, whether it be on purpose of the drafters or not, the Paris Agreement and its more flexible legal nature than, say, Kyoto has led to climate litigation taking a central role in implementation here. A positive development is also the fact that this kind of strategy also opens avenues to the public to exercise the right to public participation and access to justice. And consequently, as stated in the beginning of the study, if the utilization rates of climate change continue on the same trajectory, it is likely to become one of the most effective implementation tools of the Paris Agreement in international climate law in general. So this is a constantly changing field, and it'll be very interesting to follow further developments within this. And that's it for me.
Well, thank you very much, Klimentina. That was, lots of new information for me, lots of things that I didn't know before. So if anyone has any questions right now, I invite you to put your camera on, put your microphone on and ask, or if you're more comfortable to put them in the chat function, that works as well. Otherwise, if you come up with a question later, please feel free to email them through to me or send them directly to Neela through the admin@neelawa.org.au address. But yeah, I will. Is there anyone that has a burning question right now? Well, in that case, I would just like to thank Klimentina again for her time today and for that very thorough presentation. And all the best to you, and thank you everyone for joining. Thanks very much.
Thank you so much. Thank you for your time.
Oh, hang on, sorry. One question actually here from Hannah, which is, she says, thank you for an excellent presentation. Did the Netherlands meet the target set for 2020?
They did not. So the final decision was obviously made in in 2019. So they did not. So now there's, I think, some proceedings in terms of failure to perform as well. So yeah, we'll
But
see
no
what
decision
happens.
on that yet.
No decision, I don't think so.
All right. Thank you for your question, Hannah. And
Thank you.
Yeah, I'll wrap it up. Thanks very much for that.
Thank you. Have
Bye.
a good day.
You too.
Bye.